If you are in a life partnership with someone but are not married, what happens when one of you dies? Hi, I'm Simon Dippenaar and I'm a family lawyer. In a landmark ruling in the Western Cape High Court, it was decided that heterosexual life partners are now eligible to inherit from each other in the event that one dies intestate. Now, intestacy means dying without a will. The High Court ruled that a section in the Interstate Succession Act, or ISA, is unconstitutional and invalid. The Legal Resources Centre, or LRC, applauded the judgment as a victory for life partners. Previously, only married couples were protected by the ISA and the Maintenance of Surviving Spouse Act. Opposite-sex life partners could not inherit from each other or claim maintenance respectively, as they were not considered spouses in terms of these laws. The case was brought by a woman whose partner passed away when they had been living in a permanent, stable relationship for 2 years and were engaged to be married. Evidence was also produced that showed the couple intended to start a business together and also wanted to start a family. Their lives were traditional in terms of gender roles, and the woman was financially dependent on her partner. In turn, she provided emotional support and companionship, a contribution acknowledged by her partner. When the man died in 2016, he had a will, but his mother was the heir and she had predeceased him. He had not updated his will on her passing. According to the LRC, the woman challenged the constitutionality of the ISA and the MSSA for failing to recognize and include heterosexual life partners who have undertaken reciprocal duties of support as spouses for the benefit of inheritance and maintenance respectively. The court declared that Section 1.1 of the ISA is unconstitutional and invalid because it excludes the surviving life partner in a permanent heterosexual life partnership from inheritance. The LRC welcomed the judgment because, quote, it is an important development of the South African jurisprudence on the rights of opposite-sex permanent life partnerships, unquote. The LRC went on to say, often women in such relationships are vulnerable and suffer discrimination when the relationship is terminated by death. The decision is a welcome department in advancing the rights of women to equality and dignity, especially in relationships. We welcome this judgment as a major advance for life partners who die intestate. Although we are concerned that it only covers heterosexual life partners, we hope this condition will soon be extended to all life partners, opposite and same sex. However, whatever your marital status, the best way to ensure your wishes are carried out after your death is to make a will. Wills should always be updated whenever the major life event occurs, such as marriage or divorce or the birth of a child or the death of an heir. Non-married life partners should also consider drafting a universal partnership agreement to protect their status in other matters besides inheritance. At SD Law, we are specialists in family law and experts in antenuptial agreements, cohabitation agreements, and wills. We will ensure your assets are looked after and your children cared for exactly the way you would like in the event of divorce, the end of a civil or life partnership, or sadly death. Call me now on 086 099 5146 for a confidential discussion.